not convicted in court of that.
Sir.
But it is preponderance of evidence in court.
I asked you, sir, and I'm not going to
But if I'm misstated, then I want to correct the record.
No, you want. I know what your testimony would be, sir, and that tape recorder knows what your
That's
testimony.
fine, but I'm just saying,
And
if it was a misstatement on my part, I want to.
I'm going to stand on that, sir. Now, so you
And
believe.
the tape recorder looked like that I said it was a misstatement, that I wanted that corrected.
I believe I heard you say that the offense committed with respect to the alcohol in the minors by Mr. Deane was worse than the battery committed by Deputy Zimmer. Is that what I heard you say?
No, I said that you're taking that out of context.
What exactly did you say, sir? Because thank God for videotape. What did you say?
What I'm saying is the fact of that Anthony Zimmer, from our investigation, did not know he was, when he struck the minor, he did. This man knew he was giving alcohol to a minor.
With all due respect, sir, that's not my question. Is it your testimony that Deputy Mr. Deane's provision of alcohol to minors, whether he handed it to him or allowed them to have it within his home, is more serious than Mr. Zimmer, Deputy Zimmer, punching a boy in the face 3 times?
Both of them were very serious, but I took the totality, the whole thing, not just you're trying to take and put determination on one incident. And his determination was on numerous incidents listed to do.
Okay, so in your mind, Anthony Zimmer punching a boy in the face 3 times is not as serious as allowing teenage girls to have perhaps half a beer and a Jello shot, texting while driving, using David once, texting while driving once, and inserting himself into a personal situation where he should allow another deputy to handle it.
When you
Is
add
that
all
right?
that together, that is more serious than the other one where I gave the man 30 days suspension.
Those offenses I just outlined are more serious than a deputy
When you
punching
add
a
all
boy.
that together,
Sir, let me
yes.
answer the question, then I'll wait for your response. You believe that the offenses committed by my client, the texting while driving, the use to David both once, allegedly allowing the girls to consume alcohol in his home, and inserting himself into a situation where he should have let the deputy handle it, i.e. the arrest of Stephen DeHutt, was more serious than Deputy Zimmer punching a juvenile in the face 3 times, chipping a tooth, and committing the offense of battery.
Add it together, yes.
Okay. Next contestant.
Did you mean when you said next contestant, did you mean next witness?
No.
You still want the sheriff on the?
I do, yes.
Okay.
I do. I was making that comment to myself. Okay. You know I believe former Deputy Michael Sawicki?
Yes, sir.
He's no longer with the agency?
No, sir.
Okay. Now, when did he leave the agency, sir?
Mr. Butch, I believe you're putting that all on top of the microphone. The clerk
Oh.
has just told me, so
Where is it?
it's right in the center of the
all right.
table.
Before I proceed, let me grab my notes on this point so I can maybe bring this to issue more quickly.
Those are the IAs, the complete IAs. I'm objecting to anything with the letters.
Your objection's already been sustained. I'll note my exception with the inevitable appeal. Can I hand you a copy of this?
No, sir.
Here you go. I represent this to be what I was provided as the complete internal on 5 computers files, Michael Swift. Do you recognize that, sir?
Yes, sir.
you reviewed this IA report before you made your decisions on sustained or non-sustained findings, correct?
Yes, sir.
All right. Now, and you sustained that Mr. Sawicki committed a misdemeanor injurious to the department, correct?
Yes, sir.
And that misdemeanor was battery,
Domestic violence.
battery, domestic violence. Meaning, if you say domestic violence, can I take that to mean battery against his girlfriend?
So one of the problems I'm running into is there's so many of these, and I'm just sitting back, I have to take and give those.
Well, we need to be referred to the report of investigation. I've got it right here. I'll be happy to do it.
You have a letter of discipline in the file?
Ma'am, again, reassert, and I'm not wasting time with it. But,
Give me just a second.
are you reviewing the ROI, sir?
I'm reviewing the
Okay, very well. Now, having reviewed the documents, sir, does that refresh your recollection of whether or not you found Mr. Sawicki to have committed a violation of battery on his girlfriend or domestic violence on his girlfriend? Amounts to the same thing, really, doesn't it?
Yes.
Okay, very good. Now, sir, do you recall, in the course of that investigation, sir, that Mr. Sawicki threatened to kill his girlfriend?
I'm going to object to going into the facts of this case. Once again, the sheriff's discipline of the employee is based on what was sustained findings in the IA, not all the facts that were raised through, or the alleged facts that were brought up through the entire internal investigation. What the misdemeanor injurious is not, and specifically the domestic violence charge, the specifics of that are not relevant. He found that he had violated the misdemeanor injurious to the department by committing domestic violence. That is consistent, and that's what your consideration is, not the actual facts. Mr. Sawicki's case is not before you today for determination.
Okay. Mr.
Again, I agree with the counter.
I'm not surprised. Let me,
I have a question.
Yes, sir.
I'm getting lost in all of this stuff. I can't read this fast. Did we hear these cases?
No, sir, this one was not appealed to you.
Have we ever heard them?
No, sir,
Have we
neither
ever
one,
made any
neither one.
rulings on them?
I'm sorry?
Have we ever made any rulings?
No, sir, neither of the two that have been brought before you were appealed to you.
And how am I supposed to digest all of this in 1 second?
you're not, sir. The more pertinent portions have been tabbed as 1, 2, and 3.
We would object to what he tabs as important, because obviously I may have a difference of opinion. So.
And you're free to go through the document and tell me what you think is important.
I've already placed on the record my objections to the entire IA files coming into evidence. That's not what the purpose of the consistency or the comparison is for.
I'm not going to rehash my objection, my response to that objection. The decision of the board has been made. Let me see if I can work from since the opposing counsel doesn't want all the facts to come out, I'll see if I can just work from the final
I
suspension.
object to your characterization, and if you continue in this vein, Mr. Blitch, then you're going to put me in a position to have to make a bar complaint against you, and I really don't want to do that. If you keep mischaracterizing things that I say to this board, then that's what I'm going to do.
That threat in itself
That's inappropriate.
That threat in itself is a bar violation.
It's not a threat.
In a moment, since I'm prohibited from inquiring about the report of investigation itself, I need a minute to review the notice of termination, if I may.
Yes, you may.
Page 2 of the notice of termination, sir.
You have it? I don't have a copy of that.
The notice of termination?
I do not have that in my copy.
I do not. Um, Would you like to call me today?
You need to look at somebody.
Page 2, when you're ready, second paragraph. See that, sir?
Are you looking at the ROI or the notice, or the notice of termination?
I'm looking at I'm sorry, final suspension letter dated July 27, 2012.
Okay.
Mr. Sawicki was not terminated. It's page 2 of that document. See that? Are you with me?
Yeah.
Okay, okay, I just want to, okay, go ahead.
Is the sheriff on the right page is the question.
Well, that may be,
I believe I am.
I'm right.
Yes, I see.
There.
Doing your phone.
It states on the second page of the July 27, 2012 final suspension letter to Mr. Sawicki, during your sworn internal affairs interview, you admitted that during the incident you threatened Ms. Hardy with physical harm if you lost your job. Does that reflect your recollection of whether Deputy Sawicki, then Deputy Sawicki, threatened to kill his girlfriend?
I don't recall about that part of it. Please understand
Yes, sir.
this and all those right there.
Well, that's why I
I
brought
have
the
to
whole thing.
review each and every one of them, and I
Yes,
don't
sir.
recall the exact what he said, and sometimes, excuse me, but things will keep me off, and then I will go back and remember. And I remember they had some major issues.
Well, would it help you to look at the report, the report investigation, sir?
We can go right in and ask me a question.
I'm sorry?
Yeah, what you got there? You talked about the report of investigation.
Yeah, it's in your packet too, sir. It's under, I believe it's under, tab number 1. You see that? Let me find the first page.
That's about what we got here.
Page 9 of the IA report. The report of investigation.